aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or value by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance, regardless of the results of each juror's individual weighing process. Even if you find that sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I have said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factors are sufficient to impose death must be unanimous. Your finding that the aggravating factors found to exist outweigh the established mitigating circumstances must be unanimous. And your decision to impose the sentence of death must be unanimous. You'll be provided with a form to reflect your findings and decision regarding the appropriate sentence. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. Deputy. All right, let's look at the verdict form. Unfortunately, it's a little complicated because we have the steps that you have to go through, and for each of those, you have to consider it as to each count, and there are 4 different counts. So it gets a little complicated, but I think once you get into see the pattern of it, it'll be fairly clear cut. So the first thing you have to look at are the aggravating factors, which is in subsection A. The state has alleged 6 aggravating factors. You need to make a decision as to each count what aggravating factors have been proven as to that particular count. The first one would be as to Brandy Peters. In count 1, the court has eliminated 2 of the 6. So you have 4 aggravating factors that you're to decide whether have been proven beyond a reasonable doubt or not. You would check each one that you find has been proven as to count 1, dealing with Brandy Peters. Then you would do the same as to count 2, as to the children in counts 2, 3, and 4. They're the same. The court has eliminated 1 of the aggravating factors as to them. So there are 5 potential aggravating factors that you're to determine. So as to each of the aggravating factors, as to each of the counts, you would decide whether the state has proven them beyond a reasonable doubt or not, and you would check that. If you go to page 5, the bold language at about 2/3 of the way down that page is very important, so let's read through that. If you answer yes to at least one of the aggravating factors listed in a count, so it's done by each of the 4 counts, please proceed to section B as to that count. If you answered no to every aggravating factor listed in a count, do not proceed to section B in that count. Henry Segura is not eligible for the death sentence and will be sentenced to life in prison without the possibility of parole as to that count. So you have to consider it as to each of the counts. If there are no aggravating factors proven beyond a reasonable doubt as to a particular count, you are done. You don't have to do anything further as to that count. If you find that at least one aggravating factor has been proven as to the count, then you would move on to B, which is sufficiency of the aggravating factors. And again, it's broken out into each of the 4 counts as reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in Section A. We, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. So as to each of those that you found an aggravating factor, you need to answer that question, yes or no. Then let's go to page 6, the bold language at the bottom of page 6, I think is worth reading through. If you answer yes to Section B in a count, please proceed to Section C in that count. If you answer no to Section B in a count, do not proceed to Section C in that count. Henry Segura will be sentenced to life in prison without the possibility of parole as to that count. So any of them where you say no, your job is done. If you say yes, then you need to go to C. C relates to mitigating circumstances. Again, it's broken out by counts. It says one or more individual jurors find that one or more of mitigating circumstances were established by the greater weight of the evidence. And you would check yes or no. Now, note this is not necessarily a unanimous decision. This is the first time where it does not have to be unanimous. It says one or more individual jurors. So any juror could determine that this is yes. It says, please, the bold at the bottom of the page, please proceed to Section D, regardless of your findings in Section C. Then in D, the question is, we, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt back in Section A outweigh the mitigating circumstances established, which are found in Section C. Would be yes or no. Again, it's broken out by counts. You would answer yes or no as to any where you're still proceeding. In other words, there are some where you may have already concluded from the prior subsection. If you answer yes to, now I'm on the top of page 9, look at the bold language. If you answer yes to Section D in a count, please proceed to Section E in that count. If you answer no to Section D in a count, do not proceed. Henry Segura will be sentenced to life in prison without the possibility of parole in that count. Under E, the question again is broken out by count. Having unanimously found that at least one aggravated factor has been established beyond a reasonable doubt back in Section A, that the aggravating factors are sufficient to warrant a sentence of death as to Section B, and the aggravating factors outweigh the mitigating circumstances, Section D, we, the jury, unanimously find that Henry Segura should be sentenced to death, yes or no. You would do that as to any counts that you're continuing to proceed with from early. And now at the bottom of page 10, the bold language, if your vote to impose death is less than unanimous in a count, the trial court will impose a sentence of life imprisonment without the possibility of parole in that count. It would then be dated and signed by the foreperson. So I know that's a little complicated, but it's kind of, I think if you follow it along, I think it flows through it. We've tried to make it self-explanatory. Now back on the jury instructions, page 5, right after read verdict form, The fact that a jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. I have previously instructed you on weighing the evidence and rules for deliberation. You should consider the instructions I gave you during the initial stage in making your determination. A copy of those instructions will be provided to you for your consideration. I'll come back to the last page after the attorneys have been given an opportunity to make give a closing argument. Mr. Evans.
Ladies and gentlemen, as the judge has indicated, this is a weighing process. It's to weighing whether or not there are sufficient aggravating circumstances, and they've been listed in this crime to warrant the imposition of the death penalty. The state would submit to you that there are. And when you compare them to the weighing factor of any potential mitigating circumstances, any mitigating circumstances pale in comparison to the crime that was committed on these four people. And that there are sufficient aggravators to outweigh the mitigators. And that the appropriate sentence in this case is to impose the death penalty on each and every count in this case. Now, let's talk a little bit about the case. As we have indicated, the aggravating factors, prior conviction, which is the contemporaneous conviction of the four murders. That was done for avoiding arrest, and that's the witness elimination, which the court has instructed you on, and you have before you in the instructions. That it was for financial gain. It was done in a heinous, atrocious, and cruel manner. That it was cold, calculated, and premeditatedly done, and that 3 of the victims were under the age of 12. As the court indicated to you whenever he was going over the verdict form, there are going to be some aggravators that apply to some of the victims in this case, their murders, but not necessarily to all. For instance, we know right off the bat, number 6, we know that Brandy Peters was not under the age of 12, so that aggravating circumstance would not apply to her. You also know that, for the twins and for Javante, that the court, the jury or the verdict forms are not going to include an indication of whether or not financial gain being a motive in this case, as one of the dominant motives in this case, apply to them. And we also know that you will see that the purpose of avoiding arrest, the purpose of witness elimination, isn't being requested on Brandy Peters. So I'm going to go over the number of aggravators in line. Just recognize there will be some aggravators that will apply to some victims, some aggravators that will not apply in their murders. So, and I think the verdict form accurately reflects that. So the ones we're seeking in each of the individual murders are set forth in the verdict form. All right, the contemporaneous conviction. It includes, as noted, contemporaneous conviction for a capital felony may qualify as a prior conviction. In this case, I think you will see that the evidence clearly shows that aggravating circumstances is shown beyond a reasonable doubt in each of the crimes that have been committed. And that is because that in Brandy Peters' murder that we see that there were other murders that occurred. In Brandy's case, the other contemporaneous convictions are for the 3 kids. And while there will be some photographs that were proposed that will be placed before you, I'll let you know now there will not be a tremendous amount. simply because you have them, you're able to review them. You reviewed them during the guilt phase. They were shown to you a lot. You know what they see, and you can imagine what they are, and go back and see what they are and compare them what they are should you have any additional questions. So I will do my best to limit those. So I believe in each and every case that there will be at least three contemporaneous convictions for murder that would apply in each of the four victims in this case. Therefore, I submit to you that has been proved beyond a reasonable doubt, and that you should find that aggravator exists. I also believe whenever you take a look at the evidence that you will, in your weighing process, that the weight given to that should be a very great weight should be placed on it. And very great weight should be because you have 4 victims in this case. This is not a case of a single murder. It is a multiple murder. It is a murder of a family. It is a murder of children. Now, the purpose of avoiding arrest. It was committed for avoiding or preventing lawful arrest or effecting escape. And as your jury instructions show, the judge has shown you that this applies where the dominant motive of the murder was to kill a witness. You know, the existence of other motives for the killing does not preclude the application of this aggravating circumstance. We have 3 kids. Now, these 2 young ladies had absolutely nothing to do with the child support in this case. The only reason the statement that they were killed is because they could identify the defendant. He had a choice, and we'll touch on this during the cold, calculated, premeditated part of it. If he wanted to eliminate Randy Peters or eliminate Javante Segura, he didn't have to kill these 2 little girls. He had a plan. We know he had a plan. Again, we'll touch on it a little bit more. He went in either knowing they were there or not caring they were there, that he was going to kill everybody there. The reason these 2 little girls were killed was because if they weren't killed, they could have walked in this courtroom, walked up and got on that stand and said, "This is the man that killed my mama. This is the man that killed my little brother." We have Javante. It wasn't necessary that he kill him. He too could identify the defendant in this case as being the killer of his mama. The defendant's plan included going there and doing that killing and killing these witnesses. Because where were they earlier in the day? They wasn't necessarily at home. He could have planned this when they weren't there. He could have lured Randy Peters away from the home and did it there. But he elected not to. The murder was committed for financial gain. It takes a second for it to load. We have the fact that the child support payments were owed. They were coming to be owed. And he killed this family because he was trying to avoid that responsibility. We know he attempted to go in, and the dates of when all this occurred. Everything started coming together. We'll touch it a little bit more on that cold calculator premeditated. The dates were significant. On the heinous, atrocious, and cruel. The number of injuries, remember this came from the autopsy report of Dr. Flanagan and through her testimony and the testimony of the other witnesses in this case as to the amount of injuries and the degree of injuries that occurred to Brandy Peters. Brandy Peters was shot. I believe the testimony was she had 8 wounds and there were at least 7 gunshot wounds. We know from the back of the house, from the bedroom, all the way through the house, even outside in front of the house, her blood was found. She fought back. We see the defensive wounds to the point where her nails were ripped off. We see where she was trying to block the blows, that the 7 gunshots didn't kill her, but it took her being pulled back into the house and beat repeatedly on her head and face to kill her. Heinous, atrocious, and cruel. Brandy Peters was very aware of a number of things in this case that showed that this aggravator has been proven. She was very aware of the fact she was attempting to be killed. And at some point, maybe as she got drugged back in the house and started getting beat, she was very aware that she was going to die. She fought as hard as anybody you will ever see in this situation. From one end of the house to the other, then pulled back in. Her hands up trying to block the blows that repeatedly fell on her head. over and over and over and over and over. And I ask you another question. What kind of rage, what kind of hate, what kind of vile, what kind of wickedness played into the beating that this woman took? The other thing she knew, which probably is even worse, more vile, more wicked, more cruel than anything else, she knew she was going to die. But she knew 3 little babies were going to die with her. And they did. She died knowing that. And he killed her knowing she knew that. This aggravator has been proven. And it, if nothing else alone, warrants the imposition of the death penalty in her case. Heinous, atrocious, and cruel as it relates to the kids. Tamaya was shot in the back of the head. Tamaya's death, somebody could say, well, you could say it was somewhat merciful because she didn't have to go through the drowning that her siblings went through. She didn't have to go through the beating that her mother had to go through, shooting and beating. I submit to you, it was not merciful. It was merciless. In its own way, it was just vile, cruel, and wicked as anything else. Remember Henry Segura? He told, I believe they said at least 23 to 26 lies. They were talking about, they were documenting as they were going through his statement. But one of the biggest lies he told that wasn't brought up then was his claim that he loved these children. Love doesn't do this. Wickedness, violence, cruelty does this. To have a bullet put in the back of your head by somebody who you love, who's supposed to take care of you, is heinous, atrocious, and cruel. Tanai Peters. Remember Dr. Flanagan talked about 10 to 20 seconds after they breathe in the water. So once the water is in the lungs, 10 to 20 seconds. Remember Mr. Fuchs stopped and waited 20 seconds. That's when you got water in your lungs and you can no longer breathe. After the lights go out. But what did it take before you get the water in the lungs? Your mama has just been beat from one end of the house to another, shot multiple times. Remember the crime scene technique? Children get scared. What do? They run hide. They run hid. Unfortunately, it probably was in the bathroom. So they're hearing this horrendous event occurring outside. Sister has a bullet in the back of the head. Mama has been shot multiple times. Gunshots are ringing throughout the house, and you see it's not the largest house in the world. She's running up and down, trying to get out, trying to fight. Blood is everywhere. Everywhere. She's fighting back. Boom, 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 as she's getting hit in the face. And little ears are hearing this. Then in he walks. After what he did to Brandy Peters, we know he has to be covered in blood. Then he takes one. Maybe it was Devontae. You can see at the bottom of the tub. Someone he believes and knows is his daddy. Picked up, placed into the tub, and held down. And what's a natural reaction when you're in the water? Whether if you're 3 years old. You're going to try to get out of that water. You're going to try to stop. You're going to want to breathe. He's held down to the point where all he can do is gasp for air. And when that happens, his lungs fill up with water. And 10 to 20 seconds later, he's dead. Remember, this is after the 10, 20 seconds. The time he had to sit there and listen to his mama being killed, his sister being killed. The time he had to watch in horror as this man walked through the door, covered in his mother's blood. And then him being put in the tub and killed. That, I would submit to you, is heinous, atrocious, and cruel. Then Tania. Who is next in line? Now, she heard her twin sister being killed. Boom. And mind you, the defendant's having to reload during all this. His mama shot multiple times, fighting her way from one end of the house to the other, outside the house, back in. More gunshots still ringing out. And then the beating. She's trying to defend herself. Shot to pieces, but still trying to defend herself. All that going on. In walks Henry Segura into the bathroom. Holds Devontae down till he's dead. Then she's next. And this entire time, wondering what's going on, why this is happening, what's about her sister, what about her mama? Oh my God, what he just did to Devontae, and why is he doing this? Why is a man who professed to love me so much doing this? Then she goes into the tub. She's held down, struggling for her life. She gulps, her lungs fill with air, or with water. Not the air she needs. And 10 to 20 seconds later, she's dead. Now, to accomplish this, took some planning, took some forethought. Decisions had to be made. Bridges had to be crossed. Cold, calculated, premeditated. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan, a prearranged design to commit the murder. You know what killing with premeditation means. To this, there has to be a heightened level of premeditation to demonstrate that a substantial period of reflection is required. And this one, a pretense of moral or legal justification. There's no way that Henry Segura can claim that he had any moral or pretense of legal justification for the crimes he committed. We have the dates. We know at some stage, November 3rd, gave him 14 days on the child support. Is this when he started thinking about it and planning it? We don't know. But we know when we look at what he did, how he did it, we know it was, he didn't just walk in and decide to do this all of a sudden on the spur of the moment. We have him outside the house for a very long time on that day, on the 17th. At some point, there was some talking. We know she calls, Brandy calls DOR hotline on Wednesday. We know before the murders occurred, the defendant got up with Tyra Wilcoxon about trying to get the throwdown gun. That didn't work out. He had his own. He had the ammunition. He set up his alibi. He left his phone, his primary phone at home. The other phone he took with him. Some people may ask why. We needed to contact Brandy to make sure Brandy was there and everything else was on his schedule in order for him to get ready to commit this crime. We know he waited in the church parking lot for hours. If you wanted to kill just Brandy Peters, why didn't you kill when it was just her? Why didn't you isolate her? If you wanted just to kill Brandy Peters and Joe Devante, why not wait till it's just the two of them? He waited 4 hours, and in those 4 hours, he had his protective clothing, because we know there were not a lot of defensive wounds and stuff on him. We know he had enough ammunition with him. He brought enough ammunition to know if the 5 or 6 rounds he had in that revolver didn't work, that he may need more. Why? Because you've got 4 people to kill. We have him killing Ms. Peters. We have him killing the 3 kids. Then he disposed of the evidence. And mind you, the cold, calculated, premeditated nature for each of these victims were, he knew Brandy Peters for sure was going to be there. That was somebody we know he fully intended to kill for everything he did. He also made sure the kids were there. He certainly didn't abort the plan because the kids were there. He carried enough ammunition to do the killing of the kids, and he did it. And when he ran out of bullets, he used what he had, which was the tub. victims under 12 years of age. 6, 6, and 3. The aggravating factors. Previously convicted of a contemporaneous, or previously convicted a contemporaneous conviction of these murders. Proven beyond a reasonable doubt. Purpose for avoiding arrest. The witness elimination. Proven beyond a reasonable doubt. There was no other reason to kill those kids but to eliminate them to be able to tell you who killed their mama. Financial gain. He wanted to do away with the Brandy Peters. You know, if you just want to kill Brandy Peters, kill Brandy Peters. If it wasn't for financial gain, then why is he killing Javante? Heinous, atrocious, and cruel. We covered that. Y'all know that it was. And the evidence shows that it was. And your verdict needs to show that these killings were just that. Cold, calculated, premeditated. That's been proven beyond a reasonable doubt in each of these murders. Been proven that these 3 children were under the age of 12. We ask you, in the case of Brandy Peters' murder, that you find the existence of the aggravating factors presented on the verdict forms, each and every one of them. Find that they warrant the imposition of the death penalty. They are sufficient to impose the death penalty. The mitigating factors, the instructions you heard, anything you want to consider about his background, what he does or what he says, or lack of criminal history. Even if you find those, and I'm not suggesting that you should, but even if you find anything mitigating about Henry Segura, these aggravating factors outweigh any mitigation that you could find or should even consider. And we ask that you return with a recommendation of death being imposed in the murder of Brandy Peters. We ask that you return with a verdict of recommending death in the case of the murder of Tamaya Peters. We ask that you return with a verdict recommending death in the murder of Tanaya Peters. And we ask that you return with a verdict recommending death in the murder of Javante Segura. Thank you, ladies and gentlemen.
Defense will not make an argument, Your Honor.
Right. Let's go back to the jury instructions, page 6. Top of the page. In just a few moments to be taken in the jury room by the bailiff. When you've reached decisions in conformity with these instructions, the appropriate form should be signed and dated by your foreperson. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case, and you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room during deliberations. Kindly turn those devices over to the bailiff while you deliberate. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. During this trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberation. These exhibits will be sent into the jury room with you when you begin to deliberate. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I preferred one decision over another. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. In closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Let's go sidebar, please. Once again, you need to remain with us. We'll let y'all step out, begin your deliberations. We'll be sending the evidence to you. Everybody be seated. All right, well, appreciate you coming back. I know that's tough to not be involved in the other part and then asked to come back. We appreciate your cooperation with that. This will conclude your service with us. We do appreciate the time and attention that you've given. Make you aware of the right, the juror, you have a right to discuss your participation or not. I don't know that whether anyone would inquire of you, but it's possible they would inquire of you. You can talk to people or not as you see fit. You're now excused, so you can govern yourself as you see fit. You can't go back in the jury room. Do you have any personal effects back there? With deputy, we need to make sure Granger's going to get their personal effects. And I'm surprised he's not back by now. If y'all hold there for just a second, he'll be back momentarily. Have we kept the evidence separated so we still have what we went through the other day? We're also sending a copy of the jury instructions with them. I had the copy just printed up, so if they have any question about the original jury instructions, so evidence can be delivered to the jury. Here he is. Okay. They have some personal effects they need to retrieve for them. We'll let you step out with the deputy. Thank you and have a good day. You can take it with you or not as you see fit. They can't go back in the jury room to get their personal effects. All right? Anything else from either side?
Your Honor, we just need to put as a court exhibit the PowerPoint.
Why don't we hold, clerk's got her hands full at the moment, let's not give her one more thing.
Yes,
But, yeah, once she gets back, you can put the PowerPoint as a court exhibit, whatever it would be. Anything else from anyone?
No, sir.
All right, we'll be in recess till we hear from the judge. All right, I'm going to summarize the results of the findings of the jury as to A, aggravating factors. The jury has found that at least multiple aggravating factors have been found as to each of the 4 counts. As to B, the sufficiency of the aggravating factors, the jury has found that the aggravating factors are sufficient as to each of the 4 counts. As to C, mitigating circumstances, at least one, the terminology, one or more individual jurors have found that there is proof of mitigating circumstances as to each of the 4 counts. as to the eligibility for the death penalty. Under D, each of the jurors found that the aggravating factors were proven beyond a reasonable doubt and outweigh the mitigating circumstances as to each of the counts. As to the jury verdict as to the death penalty, having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, Section A, that the aggravating factors are sufficient to warrant the sentence of death, Section B, and the aggravating factors outweigh the mitigating circumstances, Section D, we, the jury, unanimously find that Henry Segura should not be sentenced to death as to each of the 4 counts. Mr. Brill, have I accurately published the verdict of the jury?
Yes, sir.
Either side, we should have the jury polled.
No, Your Honor.
All right?
Yes, Your Honor.
What's that?
Yes.
They have found that he's not subject to the death penalty, and you want them polled?
Yes.
Okay. Juror number 1, is this your verdict as well as the verdict of the jury as a whole?
Yes, it is.
Juror number 2,
Yes.
juror number 3,
Yes.
juror number 4,
Yes.
juror number 5,
Yes.
juror number 6.
Yes.
All right, it's been confirmed by the jury. Bill, it appears to be in order. It will be filed. So I guess the words you've been waiting to hear were done. I know this has been a long and arduous task for y'all. We call upon jurors to do a pretty Herculean job, and they work hard at it, and we appreciate it. As I said earlier, you've been the most reliable jury for this length of time that I've ever had. We haven't had a single problem from day one. We've not had a single time in the morning or after lunch or at any other point where we had to wait on you. I appreciate that. I try to run court on time, and if everybody runs on time, it runs smoother for everybody, and I appreciate that. Let me make you aware of one right that you have as a juror. You have a right not to discuss your deliberations. That doesn't mean you're prohibited from talking about them. You can talk about them if you desire, but you have every right to simply say, I'd prefer not to talk about it. As I say, that's entirely up to you. It is quite likely that someone is going to approach you and ask you about your decision making. It's possible they approach you to find fault with what you've done. You have every right to simply say, I'd prefer not to talk about it. We will be giving you a letter from the court as you leave. It will express our appreciation in writing and give you a little certificate, but it'll also do one more thing. It does give you the ability to contact some counselors that have agreed to meet with jurors at least on a one-time basis for free to talk and see whether you feel like you need further assistance along that line. There'll be a list of those counselors in a letter that Mr. Wills will give you as you leave. You should not hesitate to take advantage of that. I know we've shared some pretty awful things with you here in this courtroom, and I regret that we have to do that. But our system works on jurors coming in and listening to the evidence and making a decision. So we do appreciate the time and attention you've given us. I'd ask that everyone stay in the courtroom until we get the jurors safely out of the courthouse. We'll allow you to go out with the deputy and have a wonderful day. And I know you hope not to see me for a long time. So y'all have a good day. All right. Any reason not to proceed to sentencing at this time?
No, Your Honor.
All right. Y'all prepared the score sheet?
We have not, Your Honor. They're all counts for capital counts, so therefore there is no score sheet on this. Normally we have to do it on one when there's not a capital.
Okay.
So,
All right. There's only, I mean, all of the sentences require a life sentence. I guess the only issue is the concurrent or consecutive nature of the sentences to be imposed. I'll let you be heard, Mr. Prince.
Leave it to the court's discretion.
All right. Mr. Pukes.
Your Honor, the state would ask for a consecutive sentence on each given the nature of the offenses. And the fact that there are in fact 4 victims in this case, they should all be accountable for each one of them.
I did have the clerk, I'm sorry, do we want to present a victim impact statement?
No, ma'am. No, sir, excuse me.
Okay, all right. I had the clerk figure out jail credit. I don't know whether that was discussed with you, but I know there was some time in Minnesota. Clerk has calculated 3,002 days of jail credit. What was the starting date you used, Madam Clerk?
It was, we helped with that. It was September the 2nd, 2011.
All right, and he's been in custody since that
Correct.
date. Is there any dispute on that amount?
No, Your Honor.
Any other issues either side wish to raise?
No, Your Honor.
Brent?
I would just ask that the court recommend to the Department of Corrections he be housed as close as possible to Leon County.
Okay. All right, Mr. Segura, based upon the jury verdict in this case on each of the 4 counts, I do adjudicate you guilty of each of those counts. On each count, I sentence you to life in prison. Counts 2, 3, and 4 will run concurrently with each other, but consecutively to count 1. So there'll be 2 consecutive sentences of life. As to count 1, you're given credit of 3,002 days. There's no credit as to 2, 3, and 4 counts 2, 3, and 4 since it's a consecutive sentence. Order $420 costs, $100 cost of prosecution, or reduce that amount to a civil judgment. I recommend to the Department of Corrections they house Mr. Segura as close to Leon County as is feasible. Does that leave anything outstanding?
Your Honor, we just had a question regarding the screen erected to ensure the integrity of the process as it related to Ms. Wilcoxon. Is that right? Remain in effect, or is that expired with the end of the case now? Ms. Baker doesn't have any knowledge or information about what will happen with that. The court directed us to screen her from that. That will be part of
Okay.
the
I'll release that at this point. Anything else?
Yes, Your Honor. There's also an outstanding warrant for Kelsey Kennard. We've already taken care of it on the international and the interstate aspect of it. We actually need you to withdraw the warrant as well.
You want it
We need you
withdrawn?
to withdraw the warrant, yes, sir.
Okay, withdraw the warrant as to Kelsey Kennard. All right, anything else from anybody?
No, Your Honor.
Mr. Segura, you have 30 days. File notice of appeal. If you can't afford a lawyer, one would be appointed to represent you. Mr. Prince, I would assume you would discuss with him his appellate rights if he desires to file an appeal, that you assist him in doing so. At that point in time, you can decide whether you wish to request public defender to be appointed to represent him, or you're going to continue to represent him. If there's nothing further, we'll be in recess.